But there's a lot of amicus briefs. By the way, there are 120 amicus briefs filed on this, an extraordinary amount of firepower back and forth. And a lot of people are trying to push the idea that this is a tax and therefore we can squirm out of it. And they've got a lot of, you know, no attorney just says, okay, you got me, I'm wrong, you know, I'm wrong. They've got a lot of firepower going into why they think it's a tax, including the fact the IRS does it. They have a lot of provisions. They say, well, the IRS is going to collect it, but we're not going to use the normal procedures for IRS collection. They're not going to levy your bank account. They're not going to do all the things that the IRS normally would do. And they're saying, oh, see, that shows that they needed to do that because it is a tax. Whereas other people are going to say, well, that shows it's not a tax. So they got these elaborate arguments to try to say that the way it's being treated means that it actually is or isn't a tax. Obviously, if it's a tax, we lose. And because of that, of course, if any justice is unsure about this, all they have to do is just say, oh yeah, I think it's a tax. And unfortunately, this kind of how things are characterized makes a gigantic difference in how court cases come out. And sometimes it's really kind of hard to read for that reason. Is you think, well, this isn't true. But so if they want to go there now, under normal circumstances, and Mr. Davis have a better insight than I do. Even though you think, well, these are great and mighty judges and justices, the act of overturning something this gigantic takes a lot of political courage. And typically, the Supreme Court is just not really that much in the business of, if they can find a way to not, they love to nibble around the edges. To be smack in the middle of a huge fight like this really isn't what they are comfortable doing. As was said at the beginning of our union, someone talked about how many armies does the Supreme Court have? None. They can issue pieces of paper, but the other branches of government can beat them up pretty severely. And so they really don't like to want to stick their neck out on something this big. However, the way this is turned into a major controversy, that may kind of be changed from what's normal. They may feel more comfortable overturning this in the current environment than they normally would. But what I was going to say is that if anybody was looking for an exit, political cover, calling it a tax, whether anybody, people may laugh at their reasoning, but it may give them an out to escape the hot seat. Do you want to?
I'm sorry to digress a little bit, but Kagan did not recuse herself. Does the Chief Justice have any power over that issue? Can he take her off this case?
I don't. No. Yeah.
So it's up to her. She's the only one to make the decision.
I have noticed, especially in Virginia law, that recusal statutes are curiously focused upon the individual judge looking within themselves. It's a curiously subjective personal decision. There's not, you'd think that it would be something like that, but it's like, do you feel that you could be objective? Now, Ken Cuccinelli was saying the other day, it's something I heard, that Elena Kagan has already participated in a previous part of this case, so he says she's not out. You're all in or you're all out. I don't know if that's true, but that's what Ken Cuccinelli said. So because she already participated, she's in.
The justices are all equal in their capacity. The Chief Justice is the one that is more equal in some sense because he's administratively able to assign who writes the opinions and that kind of thing. The other out that might be happening here is the presumption that a statute is constitutional, and if they thought that, of course, they're going to take 6 hours or 5.5, whatever it is. I think they may have. I doubt that they would premise it on that, but it could be. It could be that they say, well, that it's constitutional.
Well, that's actually a good point. That reminds me of some things that I probably ought to mention. So I'll follow up on that and say that. We all taught this idea that the Supreme Court is the great arbiter of whether or not the Constitution is followed or not. But the trouble is that there are a lot of tricks and gimmicks that go along with that. The idea that, again, they presume, on the one hand, it's like, well, we're here to guard the Constitution, but we're just going to assume that Congress is right. If Congress, for example, Congress will make statements about what the facts are, what the purpose is, and they'll just accept that at face value. They lean very far towards, again, we don't have armies, so we're not going to poke you with a stick. So they pretend to be this great arbiter of what the Constitution means, but in reality, there are so many ways that they will bend the argument to basically give Congress the discretion to do whatever it wants. And of course, part of that is going to be, relating to that, is going to be the idea of what is necessary and proper. The Congress has the power to regulate interstate commerce. Commerce, as said in the Lopez case, which I may, if I have time to explain a little bit more, describes, they mention commerce in an active sense. They talk about, they say just being passively sitting still is not commerce. They use the word, which we probably lost its original meaning, of commerce is intercourse, they say. So it involves some activity, not just the fact that something has an effect across different lines. So applying Lopez, which involved a gun, basically a federal gun law was struck down as unconstitutional, very close to the situation, based on the fact that just existing near a school with a gun is not interstate commerce. It may be against the law under state law, but it's not interstate commerce. And so that strict application would be very much in our favor. But in addition, there's also the clause that say Congress can make laws that are necessary and proper for the execution of the other laws. Now, there's a lot of debate about what that means, but that may give a huge breadth of discretion for them to play with. To say, yes, this is outside of the interstate commerce clause, but Congress can do things that Congress thinks. We may think they're crazy, but if Congress thinks that this is necessary and proper to carry out the interstate commerce clause, we'll give it to them. And so this is why there'll be a lot of play in this. What I think is in our favor, especially with some of the individual justices people are speculating about, is that if they accept this, there really is nothing left. You've all heard, I think, probably Ken Cuccinelli. Pardon?
No more federalism.
Right, there is no more federalism. Now, Ken Cuccinelli and others have said recently that people have said if Congress can make you do this, they can make you buy anything. I would say that's not even the right way to say it. If Congress can do this, Congress can make you do anything, not just buy. There really are no limits whatsoever. So not only is there no federalism, but there are no limits on Congress's power whatsoever. They can make you do, think absolutely anything they want. Because so those people who want to have some vestige of federalism will be really uncomfortable and squirming about, if I buy this, it's the death knell for any limitation whatsoever, for any kind of federalism, whatever. So I think that it's kind of like the football team on the 3-yard line. So for some justices, it may be this is the 3-yard line. We can't really go quite this far, but there's a lot of play that would allow them to go that far if they want to. So a lot of play. So there's the Anti-Injunction Act, which is oddly going to, I think it should be the other way around, and which is going to talk about whether it's a tax, which I'm sure probably is very cleverly put out there by people who know that, that justices try to find a way out. There is a principle that you don't decide something grandiose or profound if you can decide the case on a more mundane grounds. So there is a tendency to want to find, you only decide the big questions if you absolutely have to. So they're putting it out there as an invitation to escape. Sorry.
Will they actually decide on Monday whether it's a tax or not?
No.
Well, they won't. They won't decide. I mean, you won't know what they. I mean, but we won't know what the decision is for about 3 months, as we like you said. But in order to decide what they're going to discuss on Monday, if they can't move on until they decide that question.